Good afternoon, everyone. My name is Marcus Christian, and I'm a partner in Mayor Brown's global cybersecurity and data privacy practice. Welcome to our presentation today, which we are conducting in connection with the firm's recent release of its guide entitled Cybersecurity and Data Privacy, Navigating a Constantly Changing Landscape. Today's discussion is focused on recent development in state cybersecurity and data privacy law. Before we begin, I have a few housekeeping announcements. First, as noted under the FAQ widget on the right side of your screen, today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and that the volume is up so you can hear the presentation. You may also adjust the volume by opening the media widget by clicking the play button at the bottom of your screen. As a partner in our cybersecurity and data privacy practice, I regularly represent clients in matters involving cybersecurity governance, policy development, incident preparation, and incident response. My practice also includes internal investigations, among other areas. I was joined in drafting this chapter by two other attorneys in our practice. Lei Shen, a partner in our Chicago office, advises clients regarding a wide range of global data privacy and security issues. Lei was recently named to the Global Data Review's 40 Under 40 list. This inaugural list profiles leaders among the new generation of data lawyers from around the world. This honor specifically referred to Lei's deep understanding of evolving developments within the cybersecurity and data privacy industry. I am truly fortunate to have Lei as a colleague. Lei and I were joined in this chapter writing by our associate, Sasha Keck, who focuses on complex commercial litigation as well as cybersecurity and data privacy. Sasha has contributed to multiple client engagements involving cybersecurity and data privacy incidents and regularly provides counsel on internal investigations, regulatory engagement, and law enforcement interaction. It was indeed a pleasure to work together on this piece, and it benefited from our varying array of experiences counseling clients in this rapidly evolving legal area. Along with more than a dozen attorneys in our practice across the country and around the world, we have worked hard through our latest annual guide to highlight some of the most pressing cybersecurity and data privacy developments that confront businesses and to provide practical advice to manage the associated legal risks. As the global chair of our practice, Raj Day, recently noted in a separate webinar, this guide is the fourth in Mayor Brown's annual series, released to coincide with the start of National Cybersecurity Awareness Month 2018. And for the fourth consecutive year, Mayor Brown is an official champion of National Cybersecurity Awareness Month. Today's presentation illustrates the unifying theme behind this year's guidebook. That theme is change. Consistent with the global trend, the landscape of privacy and cybersecurity laws in the United States is rapidly changing. Over the course of this brief webinar, I will highlight some of the most significant changes in state regulation of cybersecurity and data privacy over the past several years. I will pay attention not only to sweeping changes, such as the California Consumer Privacy Act, but also to the gradual evolution in states' protection of consumer cybersecurity and data privacy. The sweeping change in the subtitle of our chapter refers to the enactment of the California Consumer Privacy Act. Passed in June of 2018, the CCPA is the most sweeping general privacy standard in the United States. Most state and federal privacy laws tend to focus on a specific sector or on a fairly narrow definition of personal information, but the CCPA applies across industries and to a wide range of consumer information. The CCPA also imposes a number of new obligations that go beyond those in existing federal or state privacy laws. To date, U.S. privacy laws have focused on a few areas, such as requiring disclosures regarding companies' information practices, enforcing the commitments made to consumers regarding those practices, and restricting the sharing of consumer information with unaffiliated third parties for marketing purposes. Recent attention to data issues at the state level has focused largely on increasing information security and notifying affected individuals and state authorities in the event of unauthorized access to personal information. In general, state laws have not focused on providing consumers with additional rights related to how businesses collect, use, share, or sell their personal information. The CCPA differs from that general approach. It provides consumers with new rights and protections that touch broad categories of data collected about them. As you know, a few other laws have included provisions aimed at limiting data retention. The New York Department of Financial Services Cybersecurity Regulation, for example, includes such a provision. However, the CCPA will significantly alter the U.S. framework regarding consumer access to data and data retention. Although we do not have enough time today to explore all of the CCPA's details, it is worthwhile to highlight some of its most notable provisions. Unlike many privacy statutes in the United States, the CCPA uses a very expansive definition of personal information. Personal information is information that can identify a particular household, not just an individual consumer. Companies must inform consumers about their practices with personal information. For example, in their privacy policies or on their websites, businesses must disclose at or before the time of collection what personal information the business will collect about its consumers and the purposes for which such data will be used. Businesses also must disclose what categories of consumers' personal information were actually collected in the prior 12 months. In addition, businesses must disclose what categories of consumers' personal information were sold or disclosed for business purposes in the prior 12 months. The CCPA also will give consumers the right to request the company to disclose, among other information, to them what categories of the consumer's personal information it has collected in the 12 months before the request, what categories of the consumer's personal information it has sold or disclosed for business purposes in the prior 12 months, and information about third parties to which the company has sold personal information. Finally, companies must also allow consumers to have their data be deleted under certain circumstances. Information collected pursuant to Gramm-Leach-Bliley Act, HIPAA, or for other legal purposes is accepted from this deletion requirement. Complying with the new rights to delete and disclose data may require companies to make certain operational changes to how they store and process personal information. They also may need to make changes to their vendor agreements. Since its passage, the CCPA has drawn many comparisons to the European General Data Protection Regulation, or GDPR. However, simply extending GDPR compliance efforts to data subject to the CCPA may not meet the CCPA's requirements. Key differences between the laws will require companies to closely evaluate the CCPA and ensure that they have the operational, technical, and contractual ability to effectuate the rights of consumers with regard to any personal information they collect. The law is set to come into force on January 1st of 2020, and future amendments and clarifications of the law before that date are likely. In fact, the first amendment to the law was passed just last month. Many companies are considering how the law, as written, could impact their businesses and possibly require changes to their own privacy and security practices. Beyond the CCPA, perhaps the most notable U.S. development in 2018 was the enactment of data breach notification legislation in Alabama and South Dakota. With the passage of these laws, all 50 states, in addition to other U.S. jurisdictions such as Puerto Rico and the District of Columbia, now have data breach notification laws. Many states continue to alter and refine their existing laws, creating very real compliance challenges for companies trying to keep up with the rapidly shifting legal terrain. As many of you know, 50-state surveys can quickly become stale. Many of our clients work with internal teams as well as outside counsel to track developments that could impose new or expanded legal obligations on their operations. Among the newly enacted and amended statutes, 3 trends are notably evident. First, states are generally using broader definitions of personal information in new or amended statutes. For example, Colorado's amended law now defines personal information to include student, military, and passport identification numbers, medical information, biometric data, and username or email address in combination with a password or security questions and answers, among other data elements. Other new and amended laws have similarly expanded the categories of information that would trigger notification obligations. For example, several states now require notification if a resident's health or medical information or biometric data, such as fingerprints or retinal scans, are compromised. In addition, states increasingly provide that the breach of a resident's username or email address and password associated with an account triggers notification obligations. Second, states are more frequently setting specific time limits within which notification must occur. Many laws still tend not to specify notification timeframes, but instead require notification within a reasonable time period, such as soon as possible and without unreasonable delay. However, several new and amended laws, by contrast, have established specific notification timelines. For example, Alabama's new law requires notification within 45 days, and South Dakota's law requires notification within 60 days. Colorado's recently adopted 30-day time limit matches Florida's. No state has a shorter statutory notification deadline. Finally, many states now require notification of the state attorney general or other regulatory body. Many of the newly enacted and recently amended state laws require notification of the state attorney general in certain circumstances. Some laws, such as Alabama's, require notice in the event that at least 1,000 state residents are impacted by the breach. However, many states have lower thresholds, such as South Dakota's of 250 state residents, and some have a threshold of 1. Indiana, Maryland, North Carolina, and other states have a threshold of 1. For some time, companies with national or regional operations have faced a complex legal landscape for data privacy, and in recent years, the complexity has increased. As the cybersecurity threats continue to grow, it will be important to consider how these new and amended laws impact legal and business risks. Data breach notification is not the only area of state law that has seen significant recent development. States are also crafting laws and rules to regulate the collection and use of biometric data such as fingerprints, facial scans, and iris scans. Most significantly, 3 states, Illinois, Texas, and Washington, have enacted statutes in the past decade that impose restrictions related to biometric data. Illinois started the trend of regulating biometric data in 2008 by enacting the Biometric Information Privacy Act, or BIPA. This statute sets forth a number of requirements for certain companies that collect, use, or store biometric identifiers. Among other obligations, BIPA requires private entities to first obtain informed, written consent and give written notice when they collect, store, or use a person's data. The Act also prohibits companies from selling biometric information and mandates that they establish a written policy that sets forth the guidelines for retaining and destroying this information. Texas enacted its own biometric privacy law in 2009, and Washington State passed its law in 2017. Like Illinois, Texas and Washington limit the use and storage of biometric data. However, there are differences among the states. For example, Washington allows biometric data to be sold, leased, or disclosed for a commercial purpose under certain circumstances. Moreover, Texas and Washington did not create private rights of action for violations of their laws. Illinois did, however, and numerous class actions have been filed under it since 2008. As the use of biometric data continues to develop and augment productivity and efficiency, companies will need to follow state law developments closely as they relate to the collection, storage, and use of this data. The cybersecurity and data privacy legal landscape at the state level continues to change in a variety of ways. In just the past year, multiple states have passed significant cybersecurity legislation covering a number of new issue areas. For example, in May of 2018, South Carolina passed a comprehensive cybersecurity bill that requires insurance companies to implement a cybersecurity program to protect customer data from a potential breach and to report certain cybersecurity events. This law is based upon the National Association of Insurance Commissioners' Insurance Data Security Model Law. The law takes effect on January 1st of 2019. The South Carolina Insurance Data Security Act requires insurance companies to develop, implement, and maintain a comprehensive written information security program, to investigate cybersecurity events, and notify the South Carolina Department of Insurance within 72 hours of a breach that meets certain criteria. This 72-hour reporting requirement fits with the increasing trend in the state data breach laws of narrowing the reporting time frame for cyber incidents and breaches. Also in May of 2018, Vermont became the first state to enact legislation regulating personal information data brokers. Effective on January 1st of 2019, the Vermont law requires data brokers to register with the state, implement a comprehensive information security program, and notify the authorities of security breaches. In addition, data brokers must provide clear opt-out instructions and information on any limitations to such an opt-out right. The law defines brokered personal information broadly, as it includes date and place of birth, address, mother's maiden name, and the name or address of any member of a person's immediate family, in addition to typically covered information such as Social Security number. Most recently, on September 28th of 2018, California enacted a first-of-its-kind law to regulate the security of Internet of Things, known as IoT, connected devices. The law is the first in the country to cover connected devices. Many anticipate that other states will soon pass similar laws. The law goes into effect on January 1st of 2020 and sets requirements for manufacturers of a connected device. A connected device is defined as any device or other physical object that is capable of connecting to the Internet directly or indirectly, and that is assigned an Internet Protocol address or Bluetooth address. Manufacturers must ensure that connected devices have reasonable security features which are appropriate to the device's nature and function, appropriate to the information the devices collect, contain, or transmit, and designed to protect the device and its information from unauthorized access, destruction, use, modification, or disclosure. As the passage of this significant legislation suggests, the legal landscape continues to evolve rapidly, and companies can expect continued development at the state level as interest in cybersecurity and data privacy is unlikely to wane in the near future. This concludes today's presentation. I appreciate you joining me today and hope you enjoy our guide, Cybersecurity and Data Privacy, Navigating a Constantly Changing Landscape. Have a great day.